Welcome to the Aero Export Consultants podcast. I'm John Young, and this is The Point. We took a month off for the podcast, and I'm sorry if you missed the sound of my voice, or more likely, the information dump it brings you on export compliance. But we're back now, and with this episode, we're going to take a look at a recent BIS settlement agreement making waves in the industry, and more broadly about the product classification EAR99, and how it lulls some manufacturers into making mistakes with their exports and their export compliance procedures and security. So let's just jump into it. Earlier this month, BIS announced a settlement agreement with Robert Bosch GmbH, or Bosch, at least that's how I think it's pronounced, which is headquartered in Germany, for exporting foreign-produced items to Huawei Technologies and affiliates between September 2020 and September 2024. Now, for those of you unfamiliar with more technical EAR regulations, such as the de minimis rule, or in this case, the foreign direct product rule, you might hear that sentence and think, how can we penalize a German company for exporting foreign-made products to a Chinese customer? Well, I'm glad you asked. The Foreign Direct Product Rules, or FDP rules, are U.S. regulations that subject certain products to U.S. control even when produced or located outside the United States, specifically when these items are a direct product of U.S.-specified technology or software, hence the name. The provision I'm speaking about now, that is quoted in the settlement, has to do with transactions involving sanctioned entities and plants, or facilities if you like. Specifically, quote, BIS imposed a license requirement on foreign-produced items when 1. There is knowledge that an entity is a party to any transaction involving the foreign-produced item, and 2. The foreign-produced item is produced by any plant or major component of a plant that is located outside the United States when the plant or major component of the plant itself is a direct product of U.S. origin technology or software subject to the EAR that is specified in certain ECCNs. Now, first thing I want to mention, in case you weren't familiar with the name, but Huawei, the customer in question, is a very prominent party on U.S. sanctions lists like the Entity List. Huawei is a Chinese multinational corporation that the U.S. began sanctions against due to national security concerns. As the government put it, they concluded that, quote, Huawei is engaged in activities that are contrary to U.S. national security or foreign policy interests, and its non-U.S. affiliates pose a significant risk of involvement in activities contrary to the national security of the United States. This included providing financial services to Iran and obstruction of justice in relation to investigations into those alleged violations. Now, these sanctions were wide-reaching. Back in May 2019, Huawei Technologies and 68 of its non-U.S. affiliates were added to the Entity List, followed by another 46 non-U.S. affiliates in August of the same year, and an additional 38 non-U.S. affiliates in 2020. This move against Huawei, and China more broadly if you think about it, was not resigned to just small export compliance matters either. I'm sure many of you listening have heard the name Huawei and know that the US has broadly moved away from it and China with our technology purchases. I say this so you don't think that this might have gone unnoticed by Bosch, that they were operating in dicey territory to put it mildly, and should have exercised extra caution. To return to the main premise, however, as I said, the trigger for EAR jurisdiction in this case came from the FDP rule. So evidently some aspect of Bosch's plant in Germany, or the whole plant itself, can be contributed to US technology, and because of this, the US is able to exercise some authority when it comes to the export of items to entities we have placed on restricted lists. We'll hear statements in the court documents that indicate Bosch was aware of EAR jurisdiction in some capacity later. I want you to keep in mind what the passage I read to you said, that the BIS imposed a license requirement on items where an entity is known to be involved in the transaction. License requirement, that's the important part to remember. But let's break down what actually happened first. Bosch, through 2 of its subcontractors, who are referred to as BST and ETAS, violated export controls through their transaction with Huawei. What was their transaction? According to the settlement, BST manufactures micro-electromechanical systems, or MEMS products. MEMS products have a, quote, broad range of consumer applications, including in smartphones, wearable technology, and automobiles. ETAS, on the other hand, provides software, hardware, and developmental tools for the automotive industry, as well as consulting and engineering services to support software development. Both the MEMS products and the software in question are classified as EAR99 by the EAR, and therein lies one of the root issues of the situation. EAR99 is a trap for some in industry. Because it is the lowest classification and has few restrictions on end users, many manufacturers and exporters relax when their products are classified under EAR99. They are wrong to do so. EAR99 does not mean your vigilance is over. It does not mean there are no restrictions you have to worry about. There are few, yes, but that just means that the ones that remain are all the more important because there are restrictions still in place for even the most harmless of technologies. The products in question that were exported may be classified as EAR99, but the recipient, Huawei, is sanctioned on the entity list, meaning that even EAR99 products require a license to export to Huawei, and the license application would likely be denied in these circumstances. This dynamic was one of the reasons this transaction ended in violation. The second root issue of the transaction originated from the previously mentioned FDP rule. BST's sensors at issue in these charges consist of 11 different models provided by 2 different foreign companies. All 11 models were the direct product of U.S. origin technology or software, or were produced using equipment that was the direct product of U.S. origin technology or software. In addition, the microcontrollers used by ETS that were used to test ETS's software were the direct product of U.S. origin software or technology. So not just a single aspect of Bosch's transaction was flagged by the FDP rule, all of the different components that were exported as part of the transaction managed to trigger EAR jurisdiction. Now, you might be asking how such an oversight was possible. How was such a large violation able to occur? And we'll get to damages, believe me. Well, that's where things get a little scary. According to the settlement court documents, quote, during most of the relevant time period, Bosch's export control compliance team in the United States primarily consisted of 2 employees. These employees were responsible for advising Bosch's central trade compliance function based in Germany and Bosch's non-US businesses regarding compliance with US export control regulations. Only one of these employees was tasked primarily with advising on compliance with US export controls. The second employee provided part-time assistance with US export controls compliance while also focusing on compliance with US customs and tariffs. The US trade compliance team included other employees primarily focused on US customs and tariffs who could occasionally assist with minor discrete export controls questions. Now, in case you think that number actually sounds reasonable, Bosch isn't a small-time manufacturer. A quick Google search shows that Bosch employs 41,000 people in the United States, and only 2 of those people worked export compliance, only 1 of them full-time. That is ridiculous and obviously a huge part of why this happened. The settlement documents indicate that Bosch had export compliance procedures in place. However, the export compliance team did not have, quote, sufficient expertise or resources at the time to adequately address the August 2020 changes to the EAR, namely the FDP rule that expanded the restrictions for Huawei. It seems during this time, the US compliance team was actually relying on the German compliance team for our own regulations. According to the docs, quote, communications among the US and German trade compliance teams in August 2020 showed general confusion about how to correctly interpret the product scope provisions of the FDP rule added in August 2020. This undermanned compliance team, general confusion, and poor communication led to the US compliance team relying too heavily on their German counterparts and consequently created the basis of misunderstanding that led to the FDP rule trigger. Quote, the trade compliance employee in Germany erroneously commingled the concept of the de minimis rule, which depends on a certain amount of incorporated US origin content that is controlled for a destination, and the concept of the FDP rule, which depends on the software, technology, and equipment used to produce an item rather than incorporated content. They were reading and relying on the wrong rules in the EAR, resulting in a violation. The wrong section. I brought up de minimis at the beginning of this episode because yes, they are similar regulations in a broad sense, but export compliance officers are supposed to be able to differentiate. It's a requirement. Is it surprising at all that because the US compliance team was so understaffed and under-resourced, and relying on their German counterparts to read and understand regulations, that there was a communication failure, some error in translation? I'm not surprised at all. The violations continued to occur over a 4-year period, but the red flags were going up nearly as soon as the situation began, with miscommunications and requests for clarifications that went ignored or forgotten. One was so egregious, the settlement documents plainly stated that, quote, had BST answered the specific questions in the September 4, 2020 email, Bosch's trade compliance personnel in the United States likely would have identified that the BST sensors were within the product scope of the FDP rule. September 2020, the very beginning of the issue. Bosch failed to follow up and their suppliers failed to answer, causing long-lasting chaos and significant damages. The case is riddled with such oversights stemming from the original mishaps. Here's just a few quotes I pulled from the docs for example. Quote, despite the specific guidance provided by the Germany-based trade compliance employee in February 2021 that products manufactured using Company One's epitaxy equipment could not be provided to Huawei, the production facility personnel relied on the August 2020 email provided by the BST executive and signed Company One certification without attempting to reconcile the erroneous internal Bosch guidance with the specific wording provided by Company One. or, quote, there is no evidence that BST attempted to follow up on the guidance or determine whether the FDP rule might affect BST's ability to sell its BST sensors to Huawei. Or finally, quote, between 2021 and 2024, BST employees signed multiple compliance certifications for 2 of its contract semiconductor manufacturers involved in the BST sensor production process, including Company 2. Each of these certifications noted that items produced by manufacturers were subject to the EAR and required that BST certify that it would not provide any such items to an entity with a footnote 1 designation and supplement number 4 to Part 744 of the EAR. The relevant BST personnel reportedly signed these certifications and later explained that they did so because they did not understand that Huawei was an entity with a footnote 1 designation. And as for the ETAS side of things, the failure in Bosch's trade personnel was just as bad. Quote, at the time, Bosch trade compliance personnel reviewed ETAS's sales to Huawei in an effort to ensure compliance with U.S. export controls, but they erroneously concluded that the FDP rule applied only to physical goods and not to software. Overall, it's impossible to paint a clearer picture of a compliance system in total disarray. I truly feel sorry for the minuscule compliance team Bosch had and how they had to handle such a caseload by themselves, but it cannot be denied that Bosch had huge failures as an organization, and the results were staggering. Yes, it's time to talk damages. Bosch, through BST and ETAS, quote, engaged in conduct prohibited by the regulations on 109 occasions, when they sold, transferred, and or exported items from abroad approximately $72,369,361 worth of MEMS systems, sensor products, and software, items subject to the EAR, to Huawei Technologies and its affiliates on the entity list. Now, this was a settlement, and ultimately this entire matter was brought to the government's attention via voluntary disclosure, so there was significant mitigation. Quote, Bosch agreed to pay a penalty of $36,184,680. Bosch also agreed with the Department of Justice to disgorge profits, partially suspended, with actual payment of approximately $3.6 million. BIS is suspending approximately $3.6 million of its penalty as credit for the disgorgement. Interestingly enough, the involvement, or non-involvement, of the DOJ in this case was actually the first of its kind. On the day BIS announced the settlement, the DOJ National Security Division announced their first declination under the department-wide corporate enforcement policy. Basically, the DOJ declined to prosecute Bosch, resolving its investigation and allowing Commerce to solely take control of the case. The reasons being, this decision, quote, reflects the clear benefits for companies that promptly disclose potential violations and fully assist in our investigations, according to the Assistant AG for National Security. And BIS stated as well that, quote, this settlement agreement underscores BIS's commitment to strong enforcement as well as incentivizing voluntary disclosures of past violations. So that's the case, and it was a wild one. $72 million dropped to 36. And at the center of it, EAR99 Products and an FDP rule misunderstanding. And that's why we're not quite done. The title of this episode is EAR99 Doesn't Mean Relax. And if you remember earlier, I told you to remember how FDP rules create a license requirement for exports to sanctioned entities. I hope you've been paying attention because this is a core message that all manufacturers and exporters need to understand. EAR99 is not carte blanche. It is not license, if you'll forgive the pun, to send your products anywhere and everywhere with no regard to EAR regulations. There are several regulations that still apply to EAR99 items that would implement a license requirement, often with a presumption of denial. End-use checks are still vital and a requirement for EAR99 items, and user checks as well, as made obvious by the Bosch case. Bosch products were made subject to the EAR via the FDP rule, and in turn were under a license requirement despite their EAR99 classification due to the involvement of a sanctioned entity in the transaction. Bosch failed to understand that they were under the EAR's jurisdiction and failed to correctly license their transactions, resulting in their penalties. That's the situation summarized. What could have prevented it? A competent, sufficiently prepared compliance team, a sufficient understanding of EAR regulations and export controls, a comprehensive knowledge of their own products, suppliers, and organizational structure. Without these, Bosch fell and suffered for it. Do not follow their mistakes. Get educated and understand your products, know your suppliers, ensure compliance across the board. And if you don't know where to begin for that, give Aero Export Consultants a call. We're here for all your questions and export compliance needs. Here at AEC, our motto is research done right, compliance made simple. I'm John Young, and this has been The Point.